He is on the line. Mlungisi Mthembu, the Senior Registrar in the Motion Court. Good morning, sir.
Morning, Sherry and listeners. How are you?
I'm well, and you?
I'm okay. Thank you.
Well, this is our final episode, and today we're talking appeals and reviews. So I just want to check with you with regards to everything that we have covered. What is the most important thing that our listeners should be aware of when it comes to appeals and reviews?
Okay, thank you, Sherry. Maybe let's start by making a differentiation between the two.
Mm-hmm.
In all likelihood, you will have to face a question of understanding what is an appeal or a review.
Okay.
When you are not happy with an outcome, either of a litigation or of a complaint that you might have filed with any of our public bodies.
Mm-hmm.
And insofar as both the two are concerned, you are faced with a situation where on appeals, it's all about your unhappiness on the outcome from the merits of the case, the fact in the case.
Right.
Wherein you are saying, no, but I do not disagree, or rather, I do not agree with the judicial officer,
mm-hmm.
because in my understanding, this is what transpired, this is what happened, and from what I am submitting happened, the legal principles applicable are dictating that this should be a response in legal form.
Mm-hmm.
And out of that, you are saying, no, with respect, judge or magistrate, I hear your decision, I hear the judgment if it is a judgment. However, I'm inclined to take this on appeal, mm-hmm. because factually and based on the merits of this particular case, I am not satisfied that you arrive at a proper understanding and judgment effectively.
Okay.
On the other hand, a review, like I said earlier, it's mostly on irregularities or non-happiness with the regulatory provisions in how, for an example, a complaint was handled. Okay. So it's more on a regulatory line than on what the merits of the complaint were about.
Okay.
And you're going to find most of those, for an example, with the Office of the Public Protector, mm-hmm. all their findings and reports are all reviewable. You cannot take them in appeal, but you will always have to file for a review. So as another platform may arrive at a decision that will clarify as to whether was the conduct, including all the investigation, the recommendation, and the finding, undertaken in a proper regulatory manner or not.
Okay. So just so that I can understand, appeal is findings and judgment, right? And then review is regulations.
Yes, you got it right.
Okay. All right. So you see, I have been paying attention.
Yeah, but you have to get it right. We've been talking, eh?
Eventually. All right. Mlungisi, but now the person who is dissatisfied with a judgment has rights. What are those rights, and how do they, of course, then ensure that they get themselves heard when it comes to those rights and a judgment in court?
Okay. Remember when we started, we made a differentiation between lower courts and superior courts.
Yes.
So with that understanding, the first installment we had, mm-hmm. you have a situation where all judgments from the magistrate court, from the high court, can be taken on appeal.
Okay.
So what you have there, let's rather use a criminal case as an example, mm-hmm. because both the processes are applicable in both civil and criminal proceedings. Okay. But let's rather use an example of a criminal proceeding. Say you have been found guilty of having committed an offense. I'm not going to be specific about it. And you are not happy with the finding of the magistrate. Okay? In the initial, what you ought to do is to file for an application for leave to appeal, which application will go to the same judicial officer that gave a judgment against you.
Okay.
So basically, you are asking them to allow you to take your matter to the next platform or to the next court. Both this is applicable in the lower court and in the superior court in the form of a high court. Okay?
Yes.
From there, a judgment will have to be made by that judicial officer, which judgment will say, I agree. Another court may find in another form than I did. Or alternatively say, no, I do not agree. In terms of set precedences,
Yes.
my judgment was correct.
Okay.
No other court will find otherwise. From there, if it does happen that you or the judicial officer does not give you leave to appeal, you then can right away petition the High Court to say, I have this petition, here is the judgment by the judicial officer refusing me leave to appeal. Can this court summarily look at my intention of appealing the judgment together with this judgment by the judicial officer which is refusing me leave to appeal, and decide whether or not I can bring my appeal application to the next court.
Okay.
From there, few things are most important, because the question is, what are the rights? You need to be able to get your court records. Like we said earlier on, appeals are based on the merits of the case.
Yes.
So with any other appeal you undertake, the next sitting court must be able to read through the entire transcript of the finding court to say, this is what the witnesses said, this is what your submission was, this is the evidence that was brought in, and based on this, read together with your notice to appeal and affidavit supporting your notice to appeal, we are deciding that no, you are right. The magistrate said this decision was not in order, it is being set aside, you are effectively set free if you're in prison, whatever the case might be.
Okay.
However, like I said, it is important, and you do have a right to get your transcripts. There is many cases that have failed on appeal because of incomplete records.
Okay.
Because with that, the next appeal court is not able to fully grasp as to what transpired. So those transcripts are very important, and I know there is a process for the state to pay for the same for you. However, on properly filed appeal and with compliant application will that be made.
Okay. All right. So, in the event of someone now having gone to, so we've dealt with the lower court, and a judgment was given, and they've now gone to the High Court because they're not happy with the lower court's decision, and they do an application for appeal, and there it is denied. Do they have further recourse?
Sorry, I did not get that. Do they have
further recourse? Do they have a further step that they can take?
Yes, they do.
Okay.
Definitely they do. You can then after that take your appeal to the Supreme Court of Appeals.
Okay.
But before then, there's another option where you could ask and petition the judge president to constitute what you call a full bench, which will be made of more than 3 judicial officers, 3 or more judicial officers, judges, that will take a look at the finding of one of their colleagues, so to speak.
All right.
But it's one of the options. Or alternatively, you may file directly with the Supreme Court of Appeals. And if it does not still work there, and there comes to be a point which you may argue on constitutional grounds, even if you do not win in the Constitutional Court of Appeals, you can, if you do find a specific point that says, no, but constitutionally, this should have not been the case. The judgment given and all other appeal processes are now to be interpreted in infringement of my constitutional rights. You can still even take it to the Constitutional Court. And there is this case that maybe your listeners may, at their own spare time, try to look at. It's famously known as the Prince case.
Okay.
Prince was a legal student in 1989 when he got arrested. I think he was doing his second year, if I'm not mistaken. Got arrested for possession of dagga. And out of him studying in 1998, when he didn't have to get admitted as a legal practitioner, after very, very exhaustive litigation about what had happened, got to a point where the Constitutional Court agreed with him that no, we cannot say that usage of data in your personal and private space is or rather constitute to a criminal offense.
Yes.
It's a very interesting case in the sense that it starts from when he got arrested. So if you want to take a look at it from that perspective, you end up having to run all these causes that we've gone through. From the arrest to a point where at the Constitutional Court, the court is saying, but no, you are right. This cannot be the case that if you are found using an imposition of dagga in your own private space for your own either belief system or recreational use or whatever the case might be, that will be a constitutional offense. I think we all are aware right now that usage of dagga in your private space for your own recreational purposes is allowed. So I'm saying it's quite interesting in that perspective because it runs from the point of him getting arrested back in 1989.
Sure. Thank you for bringing my attention to that one, Prince. I'll definitely, I'll definitely have to look into that one because you know what? There's just so much that isn't said when it comes to dagga and cannabis and all of that. So it is very important that we understand exactly how all of that ties in. So I'll definitely have a look at that.
Most definitely. Just on Google, type the Prince case. I think you'll start seeing links that you may read from.
Wonderful stuff. Mr. Mthembu, it has been an absolute pleasure dealing with you over the last couple of weeks. I know that we've had a bit of a break in communication because of Women's Day and so forth, but we appreciate the fact that you took time out of your busy schedule to do this breakdown with us every second week. And yeah, we definitely will be in contact with you if ever there is a situation where we need clarity. Because I love the fact that you were able to simplify everything and not use all of these highfalutin terms. So thank you so much. We appreciate you. And we look forward to engaging with you guys again.
No, thank you. And on behalf of the department, I think I'm allowed to say we thank this opportunity and the attention of your listeners. It's been a pleasure.
Thank you so much, Mlungisi. Take care.
Thank you.
Okay, then.
You as well.
Okay, then. Thanks. Bye-bye.